according to the case of the plaintiff respondent, as stated at paragraph 5 of the claim, the adoption in question was made in or about the year 1944. In that view of the matter, in the face of the above legal principle on adoption of a Hindu boy, the plaintiff respondent is completely stopped from contending and agitating that even after adoption, defendant appellant Dwarka Prasad Bhagat continued to be a member of his royal family, the karta of which was his father Nathuni Chaudhary, as he has tried to make out a case in his plea. So evidences were not considered, which were considered by the trial while reversing this.
There is not exactly a reversal of that kind. You see, when we are in second appeal and once a substantial question of law is framed, we will see how the facts they arise. They are in the same family. There is no doubt that they are in the same family.
But the evidence...
And that finding has not been reversed.
The evidences which deposition in respect of, it is my humble summation, in respect of the ceremonies carried by the elders has not been taken into consideration. That has not been taken. Had it been the case that the defendant would have been...
उनको मुझे जो कल काम करने बोले थे I have it.
Where is the evidences of the parties?
What evidence do you want?
There is a categorical statement that he has performed all the rites.
Yes,
Being a son.
let's accept it. He has performed all the rites. There is no dispute on that. It is an admitted fact. For that, we don't even need to see the judgment. There is a finding that it is an admitted fact that he performed the last rites of his biological father.
So, whether after the effect of the valid adoption, can he perform the last rites of his biological father?
Merely because he has committed a wrong by performing the last rites of his biological father. Does it amount to annulment of adoption?
When it is supported by the fact that the possession of both the brothers remained at
Possession will not give you title.
I understand, ma'am. I totally understand, but it has a corroborative effect. So far,
it is not your
so
case
far
that
the effect of adoption is concerned. Had it been the case that
you just tell us. Suppose there is an adopted son and who does not perform the last rites of his adopted parents. Does he ceases to be an adopted son?
no?
No. Similarly, if there is an adopted son and he performs his last rites of his biological father, does he ceases to be the adopted son?
In the facts of the case, yes. Why I am saying this? Because
show me some law, some judgment on this, that if a person goes and performs after adoption, if he goes and performs the last rites of his biological father, the adoption stands null.
He has not only performed last rites, he has continued श्राप भी इन्होंने किया है.
सभी कुछ किया होगा.
श्राप भी
हम मान लेते हैं सब कुछ.
तो फिर सिविलिटी कहाँ से आएगा हमारे? सिविल कहाँ हो रहा है टाइस? बायोलॉजिकल जब की यंगर ब्रदर है.
आप हमको कुछ लॉ दिखाइए, है ना? अभी कोई जूरिस्प्रूडेंस पे हम लोग बहस नहीं कर रहे हैं. आप लॉ दिखाइए कि the adoption gets nullified by virtue of this act, by virtue of the conduct of the adopted son. Show me. By virtue of the conduct of the adopted son, the adoption is null. नहीं, रिसर्च तो ऐसा कोई जजमेंट हो ही नहीं सकता. ऐसा कोई जजमेंट हो नहीं सकता. Once an adoption is always an adoption. What for?
रखा वो शीट.
Adoption नहीं, शीट नहीं है वो. It is a registered document.
Correct, but nobody has acted under it. That is why.
The deed of adoption is not under challenge.
No, it is not under.
Then that is a registered document.
That is a registered
Under the
document.
provision of law, there is a presumption in connection with its correctness, right? जब वो question में ही नहीं है, when it is not under question, then under such circumstances, how can you argue this? It's not possible.
Exhibit G दिखा देते हैं, मतलब जो ऑनरेबल पटना हाई कोर्ट ने डिसाइड जो कॉम्प्रोमाइज पिटीशन में डिसाइड किया। Exhibit G Exhibit G is dated 5/12/1947. Defendants appearing 1 and 2 and responding on 5 days application for disposal of the appeal on compromise. The parties to the compromise petition are all majors. We direct that the appeal as between the appellants and the plaintiff respondent, number 1, be disposed of on the terms incorporated in the compromise petition, which will form part of the decree on this court. The appeal is not pressed as against the remaining respondents 2 and 3 and is dismissed without notice. So, my lord, what will happen to the order, the judgment passed by the original court, nullifying the adoption. However, my scope of argument is very limited because that is not the substantial question. I am not on that particular, but it will have some way.
That's my kind of to the compromise that was in the same judgment. Compromise.
Yes, I'm saying.
A.
Please take your arguments when you
Yes,
are asked.
I'm sorry. Yes, please. Let him answer.
Make a full-fledged argument.
Are you right, sir? Yes.
The full-fledged argument.
You are executing.
ठीक है, we have seen the learned counsel has referred to exhibit. The learned counsel for the appellant has referred to paragraph 9 of the trial court's judgment and has submitted that the same finding has been reversed by the learned first appellate court by paragraph number 29.
First 24. Just 24. Paragraph 25.
By paragraph 25 of the judgment without discussing the materials on the law. The learned counsel has then referred to exhibit G, which is the order passed in first appeal number 11 of 1949 and has submitted that the appeal against the judgment passed in the title suit has been practically dismissed. In the earlier title suit has been practically dismissed.
The compromise petition, by point B and C, madam, relinquishes the portion of the adopted son's property in favor of Bhagwat Prasad Maharaj. Had it been the case that the adoption would have been proper, legal and acted upon, he would not have relinquished. It is on the pretext that the plaintiff respondent Bhagwat Prasad Bhagat accepts defendant number 1 Dwarka Prasad as the adopted son of Kalicharan. He has accepted. The court has nullified and set aside the adoption.
That's right. Then B.
B. That all right, claim and title of defendant number 2, Musamad Mankumari, holding number so and so, new holding number 315, ward number 3 of Girirdi Municipality, PS Girirdi, District of Hazaribagh, will vest on the defendant number 1, Dwarka Prasad Bhagat, and plaintiff Bhagwat Prasad Bhagat. Both.
In this particular case, this compromise was between the
between Bhagwat Prasad Bhagat, he was wife of Kushal Kumar, sister of Mal, and Mal Kumari adopted Dwarka Prasad. Against that adoption deed, the suit was laid.
Who was defendant number 2? Who was defendant number 3? And who was defendant number 2?
Number 1 is Dwarka Prasad Bhagat. Babu, Bhagwat Prasad. Defendants were Dwarka Prasad, Man Kumari, alias Man Kumari defendants.
No, there were 3 defendants now.
There were 4 defendants.
In the earlier title suit.
Sudarshan Chakra Prasad Bhagat and Mahadev Bhagat. They were the plaintiff. And the defendants was Dwarka Prasad, Man Kumar.
Who were the plaintiffs in this particular case?
Bhagwat Prasad Bhagat.
And Bhagwat Prasad Bhagat is totally alien to the family.
Yes,
He is
although he
the
has been given share.
sister of
Husband of Kaushal Kumari.
husband of
कुमारी का दोनों ही है
हाँ?
फैमिली में है ही नहीं
मन कुमारी के बहन का husband.
Man Kumari तो full sister है.
हाँ, मन कुमारी और कौशल कुमारी.
They are full sister.
Full sister.
मन कुमारी के तो मतलब एकदम ही अलग फैमिली के. Bhagwat Prasad is totally from a different family.
And he challenged the adoption.
He challenged the adoption.
And that was set aside.
And there was a compromise between the third party and the adopted parents. थर्ड पार्टी हो गए ना, ये तो फैमिली में तो फैमिली मेंबर तो नहीं बनेंगे हिंदू लॉ के अनुसार.
But there was a compromise between Man Kumari, the defendant number 1, Dwarka Prasad.
Who was the plaintiff in this case?
In
The
this
suit.
This suit, Bhagwat Prasad Bhagat.
This was title suit number
18 of 47.
18 of 1947.
18 of 47. ये थे प्लेंटिफ. डिफेंडेंट कौन कौन थे?
Plaintiff 2 है, मतलब 3 इसमें, according to the appellants जो compromise उन्होंने फाइल किया है, versus about Bhagwat Prasad, just on the next page, compromise हुआ होगा, उसके अगले पेज पे compromise petition,
हाँ.
उसमें verses में है first Babu Prasad Bhagat, plaintiff, सुदर्शन चक्र प्रसाद भगत एंड महादेव।
नहीं, ये कहाँ से बन गया? एग्जिबिट एच,
एग्जिबिट जी के हाँ एच जो कॉम्प्रोमाइज है।
एच में कहाँ से आपने?
फर्स्ट पेज
फर्स्ट पेज में तो इन द मैटर ऑफ कॉम्प्रोमाइज।
हाँ उसमें पार्टी है
नहीं, पार्टी इसमें नहीं दिया हुआ है, इसमें द्वारका प्रसाद एंड अदर्स वर्सेस भागवत प्रसाद एंड अदर्स करके दिया हुआ है।
मैडम उसमें भी होगा सब्सिक्वेंटली इसमें भी वही चीज है।
नहीं, ये दोनों टैली ही करते हैं। ये डॉक्यूमेंट यहाँ एग्जिबिट नहीं है। एग्जिबिट जी,
कॉम्प्रोमाइज पिटीशन में और पार्टी
एग्जिबिट जी इज जस्ट वन पेज द ऑर्डर।
हाँ वो मदर
ठीक है, उसके बाद कॉम्प्रोमाइज पिटीशन है जिसमें पार्टी पोजीशन नहीं है। ये एग्जिबिट एच है। एग्जिबिट जी का जो आप बोल रहे हैं ना, वो नहीं है उसमें खाली वही है कॉम्प्रोमाइज। ये कॉम्प्रोमाइज डिग्री जो है ना, जो अल्टीमेटली जो पार्टी पोजीशन के साथ डिग्री बनी है, वो नहीं है एग्जिबिट।
कॉम्प्रोमाइज पिटीशन एच
आपको दिखाती हूँ।
अभी टाइटल सूट में देखेंगे यूनिवर्सिटी टाइटल सूट का जजमेंट में, तो इसमें पार्टी पोजीशन दिया है लेकिन ये सब डिपेंडेंट शो कर रहा है। सुदर्शन चक्र प्रसाद भगत और महादेव प्रसाद भगत ये भी एग्जिबिट हुआ है टाइटल सूट।
प्लेंटिफ में कौन कौन थे?
प्लेंटिफ में केवल भागवत प्रसाद शो कर रहा है इसमें टाइटल सूट के जजमेंट में।
और डिपेंडेंट कौन कौन थे?
द्वारिका प्रसाद भगत,
हाँ,
उस्मान मान कुमारी, थर्ड सुदर्शन चक्र प्रसाद भगत, फोर्थ महादेव प्रसाद भगत ट्रायल कोर्ट के जजमेंट में। और इनका पार्टी पोजीशन डिफेंडेंट शो कर रहा है चारों का।
बाकी प्रोफॉर्मा होंगे ना? बाकी प्रोफॉर्मा होंगे।
दिख नहीं रहा।
द्वारका प्रसाद और मान कुमारी, इन्हीं लोगों ने अपील फाइल किया। Plaintiff was the respondent, and then the other two were pro forma.